Okay, looks like we have everybody connected, so we'll get started with the hearing. I guess what I'd like is for counsel and whoever's going to argue the motions today. So whoever those counsel are, if you could put your appearances on, starting with the Ward Brothers party.
Yeah, good morning to you and your staff, Your Honor. Brian Kaplan on behalf of counter defendants, Ward Brothers LLC, Bernie Ward, and Sandra Ward.
Thank you.
Good morning, Your Honor.
All right.
Zachary Stewart on behalf of the plaintiff, Ward Brothers, and counter defendant, Heather Ward.
Thank you.
Your Honor, David Dobrev. I'm the attorney for Northern Michigan Elder Law. I'm representing myself pro se as a counter defendant, and I have several employees appearing here with us that are also counter defendants I represent.
Okay, so Mr. Dobrev, you're attorney of record for all parties on your side?
Yes, I misspoke. Counter defendants, counter plaintiffs, Your Honor. For Marilyn Gillard, Jennifer Bartlett, Emily Evans individually, as well as Twyla Johnson and Jill Smigilski, who unfortunately could not make the hearing tonight.
Okay. All right. Thank you. So we're on the record today. We originally had this hearing scheduled for October 16th. I appreciate counsel's patience. I had a family emergency I had to attend to that day, so the court had to move the motion hearing to today. In the interim, I believe Heather Ward also joined in the original motion through her counsel. I've had a chance to review all the briefs, the attachments that were submitted from both sides. So today is the opportunity for the court to hear oral argument. I do want to officially go on the record, though I neglected to do that. So this is, and I'm just going to go by the original caption, Ward Brothers versus Northern Michigan Elder Law, although of course there are counterclaims here as well. This is Charlevoix case number 250848-28-CH. I'm presiding over this matter by assignment from SCAO. And in terms of oral argument, this is the plaintiffs and counter defendants motion. So Mr. Katranar or Mr. Stewart, whoever would like to proceed with arguments on behalf of your respective clients.
Yeah,
I'll let Mr. Katranar go first. Go ahead, Mr. Katranar.
Okay, makes sense. Thank you. Your Honor, do I have to put my appearance back on the record now that we're on?
No, we're fine. Thank you.
Okay. All right. So, Your Honor, I guess there's quite a few claims in this case with respect to the counter complaint that was filed by the counter plaintiffs. As it stands, there's 7 counter plaintiffs that have alleged 10 claims against 4 counter defendants in that complaint. There's a total of 280 claims just on the counter complaint alone. And most of those, as our briefing indicates, are legally deficient. So the purpose of this motion, the counter defendants just wanted to seek partial summary disposition to eliminate those claims that are deficient so that we can have like an efficient and orderly discovery period in this case. And given the breadth of the allegations and the amount of claims that are involved, I don't want to just regurgitate what's in our brief. I would like to more specifically focus on any questions that the court had with respect to any one of the arguments that we made. So I would invite any questions that the court has, or I can just get into the arguments.
Yeah, I don't really have any questions at this point, unless Mr. Dobrev says something that raises a question for me. But I thought both sides were clear in their briefing. I feel like I've got a pretty good handle on what the issue is here. So
I thought that might be the case, so I'm not going to waste the court's time or anybody else's time going through each of those arguments. I guess the only thing I would like to bring up is just, the response brief and the issues raised by Mr. Dobrev. I think he argues that our motion improperly cites to documents and information outside of the pleadings. I think that's just patently false. Our briefing focused specifically on the allegations of the complaint. We never left that complaint. So I do think that the C8 portion was proper. Mr. Dobrev also raised an I2 portion motion for himself. I think that goes outside of the scope of the motion that we actually filed. We haven't filed any responsive pleadings in this case, so to bring a motion based on the pleadings seems a little bit inappropriate at this time. And then I think he also brought up the standing issue, saying that, all the counter plaintiffs do have standing. And I would just quote from the Lansing case. It just says, quote, "The standing inquiry focus on whether a litigant is a proper party to request adjudication of a particular issue." That's the Lansing case, 487 Mich at 355. And that's precisely what we're challenging here. A lot of these claims are brought by individuals that simply aren't proper parties to request adjudication. So we would just ask that the pleadings get cleaned up in this case. And, hopefully, like I said, we can proceed with an orderly discovery period so that we can get to the bottom of what the legitimate claims are.
Thank you. Mr. Stewart, anything to add on behalf of your client?
I won't add much more. I agree with Mr. Katrinar, and I think that the court put it well when you first started this earlier, that we joined in because of the delay, really, and obviously we understand that. And with respect to Heather Ward, it was in our motion itself, and I'll reiterate it on the record right now that Heather Ward is not a member of Ward Brothers LLC. She's got no interest or say in the ownership of the property. That's the issue of this lawsuit. She has no say in the agreement that ties the two buildings together, the Belvedere agreement. She lived in the building for a short period of time, and the actions that are stated in the counter complaint are not enough to amount for any liability for Heather Ward. And so with that, I would just reiterate that Ms. Ward's position is on the same basis as Mr. Katrinar with his representation of the other counter defendants.
All right, thank you. Mr. Dobrev?
Thank you, Your Honor. Let me make sure I'm on. I find it interesting that Heather Ward suddenly is, not engaged and was not complicit in what's happened here, considering it took most of the delay that happened in the front end of this counter complaint was the delay in service that the current party representing Heather Ward refused service initially. She was only served shortly before we were about to hear a motion for alternative service, which was another ridiculous delay. It's pretty simple what we have here. We have a Ward family combined effort. They've engaged in a multi-year coordinated campaign to destroy my law firm, to intimidate me, to physically obstruct my deeded restricted parking covenants, my property rights. Through the limited discovery we found, I've discovered you can stand in their apartment and listen to my client and our conversation standing in our waiting room, let alone now because of the removal of the insulation, we've discovered that you can hear people going to the bathroom. And my clients and my employees have had to endure Bernie Ward coming over to our office and confronting them on their bathroom usage. What we have before us is a procedural fog issue here, Your Honor. I think that's what they've created. Just that legal principle established by the former owner in this case, like Bob Hoffman, he set this up, him and the former owner before the Ward brothers. There are restricted covenants that run with the land. I think it's really important to point out the two sides of the coin, that they're both the Ward Brothers LLC and the individual counter defendants, Bernie and Sandra, are seeking to put before the court here by trying to get away with kicking out counter complaints. However they multiply because of the years that have gone on in this thing. All of this to me it was a conspiracy that started with Heather and the behavior of her while she was a tenant. She's on video. That's part of the initial complaint, counter complaint. It's cited in there. They of course said it's false and untrue or misleading or whatever their answers were to it. They've negated that. They've been aware that she stated, "I'm tired of the war," indicating she was involved in some sort of war. I was trying to run my business after the successor to the Hoffman and Hoffman law firm, as I was his succession retirement policy. Part of that agreement was I was going to buy the building if that went through, which I did in 2022, Your Honor, with the help of my wife. And I'm the sole owner of Northern Michigan Elder Law, a professional limited liability corporation. I'm a lawyer that is employed by that corporation. I'm a W-2 employee, and I have a W-2 employee attorney, Emily Evans, sitting here, who's a counter plaintiff. I have employees that have a right to go to and from work, and frankly, their rights are intertwined, as they have a right to park in the parking spots that are afforded them at their business, and they can't go to work without being able to park there when there's, on the low end furniture.
All right, Mr. Dobrev, I mean, do individual employees have a right to bring a trespass claim?
I believe they do, Your Honor. I believe I do, as the owner of the property through Northern Michigan Elder Law. They certainly have a right to bring a nuisance claim.
I'm not asking about a nuisance claim. I'm not asking about a nuisance claim. I'm asking about a trespass.
The trespass argument is valid to Northern Michigan Elder Law PLC.
What about the other?
There's no question about that.
About the other counter plaintiffs.
That's all stuff that can be worked out. Like I still think the
that's not my question. Mr. Dobrev, that's not my question. My question is, do employees who don't have an ownership or possessory interest?
No, not as to trespass, Your Honor. No, nuisance, yes.
Okay, so why would your claim for trespass include all of the individual counter plaintiffs if they can't recover?
It's no displeading, Your Honor. It's that doesn't have to be like fraud and the other pleadings. It doesn't have to be pled with specificity. They just have to be put on notice that they've trespassed on property, whether that's the plaintiff is one of the several or two of the several. They still trespassed.
Okay, so if this were to go to a jury trial and the jury awarded damages on the trespass claim as to all plaintiffs, which is how it's pled, then how do we decide who gets the damages? Would we have to add an extra jury question in there as to which plaintiffs you're awarding?
I think they would decide that if by law they couldn't do it, then the jury instruction when we got to that point would be, by law the individual plaintiffs don't have a right for trespass, but they do for nuisance, so you can allow damages for that. We're not even through discovery yet. We haven't even started a scheduling order, and this thing got filed in March.
Okay, all right, thank you. Any other arguments on your behalf?
I think if you look at and why I think my counter motion for decision on these pleadings is valid. Look at the complaint, Your Honor. This is on the complaint alone. They filed for money damages individually. Bernie Ward incurred these. Sandra Ward incurred these. They're asking me to pay for their Marina boat pump station, which is the business located behind us, and the repairs that are related to that. All of these repairs, with the exception, I think, of one invoice, predate my ownership. The concrete work's done in 2020 when they unilaterally removed a tank from outside the building that had nothing to do with the structural components of the building. Yet they're sitting here today using the Ward Brothers entity to get recovery for the damages to that. But then they're arguing that my individual plaintiffs don't have a right to bring claims against them because they're not part of my LLC. What is the fraud in this case? I think the fraud is clear. They filed fraudulent receipts that have nothing to do with anything in this lawsuit or anything with Northern Michigan Elder Law, represented them that they did, represented to the court and that they somehow are entitled to damages. They've negated to the fact that that Northern Michigan Elder Law and myself have reimbursed them over $2,000 for the cost since I've owned it. Everything that is mutually related to our shared wall structure, I don't even question. I paid it. I paid a $1,711 invoice. I paid a $253 invoice. I replaced a flower pot that was actually in my parking spot that I hit. You know, I paid for everything that would have been shared. And I'm not even sure this agreement makes me pay for those. What I think is really important here is they didn't add themselves as non-parties. They didn't add Robert Hoffman, who owned the building before. They sued me. And they continually interfered with our rights to enter our property. They made it difficult for our clients, our senior clients, to enter our property. I don't think that their claims about standing are even remotely accurate. I think standing under Lansing's pretty clear that if you have a specific injury, special injury different than the public, you have a right to sue. They certainly have a nuisance claim. They certainly have an invasion of privacy claim. Once we learned they were listening to our bathroom usage in our conversations in the office, they certainly can join in the conspiracy claims. You know, and as to Heather Ward, she's not a bystander. She was one of the initial tortfeasors in this whole thing. It's irrelevant whether she owns something or not. If the tenant throws a brick through my window, the tenant can still be reliable. Under Adkins, the case I cite, liability for nuisance and trespass, or at least nuisance, attaches to the actor who causes the invasion, not the deed holder. It's irrelevant if she's a tenant or a visitor to their property. She's doing so under their instruction. She's a tortfeasor. If she's doing it under their instruction, she's conspiring with them. I've submitted video evidence. I think it's very clear she's indicated I'm tired of the war, and they sought advice from police officers and claimed in that video that the police officer said something different, but clearly failed to show them the actual restrictions. They ignored all of the police officers' attempts at intervention, including our prosecutors. She's not a bystander. She's an active combatant in this thing. She physically put her lawn furniture out there, but she wasn't as bad as her parents, which 2 years later were putting their outdoor refuse in my parking spot. There was dog poop and covering all of our parking signs. I'm a professional business. Having clients show up to your business like that, there's fundamentally something wrong here. You know, it seems clear to me this is 3 years that Bernie Ward, Sandra Ward, and Heather Ward, while she was there, they wanted to put me out of business because the building's more valuable to them because they own the building, the business behind them. They own the building next door to me. And they were shocked when they found out I bought it.
Okay, Mr. Dobrev, I think we're getting outside of the legal arguments here. Do you have any more legal arguments to support?
No, I'll just conclude, Your Honor. I'm hoping that this court sees through the smokescreen. None of their claims on the complaint are valid. They failed to join Bob Hoffman. If he was responsible for anything, he owned it before I did. He benefited from it. I didn't. They're seeking expenses for their marina and things that shouldn't be charged to my business. I have an exclusive right to that westerly parking covenant, just like I can't interfere with their parking covenant. I'd ask this court for a declaratory judgment. I'd ask you to dismiss their complaint with prejudice. I deny Heather Ward's motion. She's a primary actor in the nuisance. Judgment on liability. I'd like this thing just to go to the jury with damages at this point. This is an unbelievable stress that it's got me into, and I'm trying to practice law. Sure, no one has sympathy for that, but it's very difficult. I don't have anything further, Your Honor. I appreciate your time, and I'm very thankful we're in front of you in court.
Okay, all right, thank you. Mr. Katrinar, Mr. Stewart, it's your motion, so I'll give you both an opportunity to respond before I make a ruling.
Yeah, Your Honor, I think just very briefly in response, I think most of the issues touched on by Mr. Dobrev have been addressed in our brief. So I would just rely on our briefing in response to most of that. But the one thing I would say is, I think this is a good example of what the problem is here. Is number one, there's a ton of claims alleged by all parties against all defendants, and all we're looking to do is clean that up. Arguing we're not arguing on behalf of our clients, I should say, that this entire complaint needs to be dismissed. All we want to do is make sure that we have an orderly discovery period so we know which claims are being alleged by which people against which parties. And I think our briefing in this motion served to clean that up and kind of admit where they have met the pleading standards and just seek dismissal of those where they haven't. And then with respect to, again, I think part of the issue here is we've gone from a request to clean up the pleadings to him asking for summary disposition of the original complaint, which is not at issue here. So it seems like there's this scattered shot kind of going in all different directions approach to this. And again, all we're looking to do is clean this up so that we don't waste a ton of time in discovery, that we don't have to go through 10 different claims at depositions with 7 different plaintiffs, have the true claims that have been properly pled here so we can get through discovery, figure out what the facts show, and, proceed forward in that fashion without wasting a bunch of time and without, the potential for a lot of discovery issues and extended discovery periods needed to accomplish all that work. So that's what we're looking for. And again, we rely on our brief. I think all of the issues have been adequately briefed. And without any additional questions from Your Honor, we would rest on those.
Thank you, Mr. Stewart.
I'm in agreement with Mr. Ketchner. We did ask for a C8 on all counts against Heather Ward. And I guess as a response to that and sort of a modification of that, I would say that while we believe that none of these counts or claims against Heather Ward amount to a potential liability of Heather Ward, we certainly stand with the same idea that Mr. Ketchner has put forward to the court. We need to clean these pleadings up so that we can take discovery and accomplish the goals that need to be accomplished. And obviously, if Heather Ward needs to stay around a little bit longer because there are some questions of fact with respect to a potential nuisance claim or some of these other issues, then we would, we'll go forward with that and we will take discovery on that and potentially move for a motion later on. But I will stand with Mr. Ketchner in terms of the way that the pleadings, the way that the motion has been set forward, and with respect to the idea that we are trying to clean this up so that we can take discovery in an efficient and orderly manner.
Okay. All right. Thank you. So again, I did have a chance to review all the written submissions of the parties. I did review the amended counterclaim very carefully in light of motions here. So first of all, I guess I would say, number one, I'm looking at this stage of the procedural posture of the case. And really, and I think Mr. Stewart and Mr. Ketchner have really kind of alluded to this, maybe unintentionally with their statements here, which is we need to clean up the pleadings. And so I'm viewing this much more as a motion under 2.115 to correct pleadings or for more definite statement than I am really a motion under C8. I really don't even think we're at that point yet, given the pleadings. And I think kind of the arguments of the moving parties bear out the way that I'm looking at this and after having read it. So I'm actually glad to hear them use the words like cleaning up, because that's the way I view this. I understand why it was filed as a C8 motion. I get that from a procedural standpoint, but I really think it could have been and maybe should have been filed under 2.115. Certainly, Mr. Dobrev, your argument regarding the law as the pleading is correct. And in the Lansing case says what it says, and it is notice pleading. However, notice pleading, part of notice pleading is making sure that the pleadings are sufficient to show who is suing who and for what, and on what basis. And Mr. Dobrev correctly cited Lansing in that a litigant has standing whenever there's a legal cause of action or the litigant meets the requirements of a statutory cause of action. And I don't think it's good enough to just group all plaintiffs into one and say, well, that's notice pleading because the defendant knows what's being claimed. Well, they know that there's a trespass claim, but they don't know who that claim is being made against and on what basis. And so I don't think what counter plaintiff has done in their amended counterclaim meets the standard of notice pleading. And I think Mr. Dobrev's brief, kind of even acknowledges that, because right after the sentence where he cites to Lansing, he states, here each count implies which counter plaintiff asserts that claim. And I don't think it's good enough for a plaintiff to just list all plaintiffs in a claim, whether or not that claim is actually recognizable, whether or not any of those individual plaintiffs actually have legal cause of action or a statutory cause of action. And the example I would use is the one that I raised here today, which is the trespass claim, where some of the plaintiffs here who clearly don't have a possessory or ownership interest in the property they don't have a legal cause of action or a statutory cause of action for trespass. And I don't think it's good enough to just say, well, the defendants should be able to figure it out by implication. And later on in the brief on page 11, Mr. Dobrev states, David Dobrev, assuming individually Mr. Dobrev, and other employee counter plaintiffs plead limited claims. He makes that statement in the brief, but all the claims that are pled are to all plaintiffs. So to me, that's a problem. And to me, that's not sufficient to satisfy notice pleading and provide notice to the defendants who is suing who for what and on what basis. And I think the argument that, well, we just send it all to the jury, and then if there happen to be some plaintiffs who legally can't recover, we just tell the jury, well, you can't recover for those claims. Number one, it would never get that far because the opposing party would be moving for a directed verdict at the close of proof, saying there isn't any evidence on which a jury could give these certain plaintiffs any relief. But I also think it's just not a good argument to say, well, we're going to admit as for part of this motion hearing that some of these plaintiffs can't bring a motion for trespass, but we want to make the defendants defend those claims all the way through to a jury verdict. I mean, that just doesn't make any sense. So, and it's certainly not permissible under the rules of pleading or notice pleading. So I find that the defendants are correct that these pleadings need to be cleaned up, that the counter plaintiffs need to plead with specificity who is suing who for what and on what basis. And if there are plaintiffs that can't, on the face of the pleadings, meet the statutory requirements for pleading a trespass, then they can't be included in those counts. And the counter plaintiffs need to, again, plead their claims so that plaintiffs that clearly are not entitled to relief under a particular claim aren't included in that claim. So I'm granting the motion, but I'm granting it as a motion under 2.115, not a motion for summary disposition. So the court is not dismissing any of the counter plaintiffs' claims at this time. The court is going to order that counter plaintiffs amend their counterclaim within 30 days to comply with the court's ruling on the record here today. And then counter defendants, to the extent that, those pleadings still do not plead a cause of action. The motion here under C8 is being, again, I'm not deciding it under C8, so it's without prejudice. Counter defendants are more than able to file another motion for C8 to the extent that the amended, which would now be the second amended counterclaim, doesn't set forth legal or statutory causes of action with regard to any particular plaintiff. With regard to the counter motion here, a lot of the arguments made by the counter plaintiffs here involve factual allegations, which I have no idea whether they're true at this point or not. Certainly would need to be supported under C10 with documentary evidence. Then the counter defendants, of course, would have the obligation to bring forward documentary evidence to counter those, at least to create a question of fact. But certainly as it sits here, just based on the pleadings, I cannot say that the original complaint, which Mr. Katrinar is correct, that's really not before the court today, a motion on the original complaint. But certainly as to that complaint and to any of the defenses to the counterclaim, certainly there is not enough before the court at this time to find that there's no question of fact that the counter plaintiffs are entitled to any kind of relief, such that the only issue that would be left is for damages, just based on the arguments here today. So for those reasons, again, the court's granting the motion pursuant to MCR 2.115. The court is denying any motion pursuant to 2.116 or I5. And so Mr. Katrinar, I believe you were the original moving party here, so I would just request that you prepare an order that reflects that ruling of the court today. This ruling applies equally to Heather Ward. Again, I'm not making any factual determinations today about whether or not she has liability. Mr. Stewart, some of the arguments you made here today certainly were factual arguments as to her degree of her involvement. Mr. Dobrev made counter arguments as to factually her degree of involvement. I'm not in a position to be able to rule on that today without any kind of documentary evidence, certainly not just based on the arguments of counsel. So, but I do think Heather Ward is equally entitled to a more definite statement of the claims here. So the ruling as to 2.115 applies equally to her, joined her in the motion. And then again, the order should direct that counter plaintiffs have 30 days to file that complaint, and then we'll go forward from there. That's all I have for today. I appreciate all the arguments of counsel here on the record today, and everyone's free to disconnect. Hope everyone has a pleasant Thanksgiving.
You too, Your Honor. Thank you very much.